Imagine having 12 third-party companies and industry professionals coming to your defense when the SEC is suing and harassing you. Well, that's what Ripple has. Ripple now has 12 companies that have come to their defense in this SEC versus Ripple case. That's right. How is this going to affect the case going forward? And what can we expect? Let's talk about it. Hello, everyone. My name is Sean. I am the Crypto Smith. Thanks for checking back in with me on the SEC versus Ripple case. This is going to be just a quick update on what's happening now. Nothing's been resolved. Nothing's been decided, right? We're just keep pushing this case down the road. We are coming up. So it's been about 2 years now since the SEC has filed a lawsuit against Ripple, alleging they illegally sold securities way back in 2013. This case is dragging on forever. And now we have 12 amicus briefs that have been filed on behalf of Ripple. So what does this mean? What is an amicus brief? Well, basically it's just a legal document, right? It's a brief that can be used to bring relevant facts and arguments to the court that maybe hasn't already been brought up. So basically what they can do is they can show in this case that these companies and industry professionals that I'm going to show you all have different reasons on why they purchase XRP. None of which is because they thought XRP was going to go up in value because of the efforts of Ripple, the company. So we can go through them all individually. We're not going to go through them all, but I'm going to go through a couple and just kind of give you the basic outline of what their brief entails. So this one here is Brad Garlinghouse in a tweet. For those of you keeping count, 12 amici briefs submitted. It's unprecedented, I'm told, to have this happen at this stage. They each explain in their own way the irreparable harm the SEC will do to every facet of the U.S. crypto economy if it gets his way. Right? Stuart Alderati, which is Ripple's head counsel, says a dozen independent voices, companies, developers, exchanges, public interest, and trade associations, retail holders, all filing in the SEC versus Ripple to explain how dangerously wrong the SEC is. The SEC's response: we need more time, not to listen or engage, but to blindly bulldoze on, right? That's what the SEC does. So these are the companies that have come out now. And industry associations, Chamber of Digital Commerce, right? Very big one out there. They've written an amicus brief on behalf of Ripple saying how the SEC is incorrect in their the way they're applying the law. Now, TapJets here, they say they've been purchasing XRP to pay employees, right? So this is one of those things where they're actually utilizing the token on a daily basis, and they're not holding it just to try to make profit based on the efforts of Ripple. We've got iRemit. Now, iRemit uses XRP for on-demand liquidity for international payments. I'll leave this article in the description down below so you guys can go check it out. You just click on each one of these and you can, it'll explain exactly what they're doing and what they're talking about. I'm just giving you a brief overview on what it is they're saying. And so iRemit uses the ODL, which is on-demand liquidity from RippleNet to make international payments. That's why they use it. That's why they use XRP. They explain that in the brief. Let's see. We also have Coinbase, right? Coinbase, obviously the largest centralized exchange in the U.S. They file an amicus brief in favor of Ripple against the SEC. This filing, though, is a little different because they're coming out and basically saying that Ripple didn't have fair notice, right? So they're addressing the fair notice defense, and they are explaining why they believe the fair notice defense should stand. But it doesn't really help in this case because in the summary judgment motions, right? Nobody was arguing the fair notice defense. So this may not have as much impact as the rest of them do. Spin the Bits. Spin the Bit says Bitcoin transactions on XRPL take 5 seconds as it declares support for Ripple in the SEC. So Spin the Bits, their argument was a little bit different than TapJets and iRemit. While those others can use on-demand liquidity solutions, Spin the Bits actually uses the XRP ledger to transfer Bitcoin, right? You probably didn't know it could do that. I recently learned of that myself. Payment Solution noted that its amicus brief would provide the court with meaningful information about the case. The development comes after the court granted iRemit and TapJet's request for leave to file amicus briefs, right? So another use case for XRP. And then we come down to the big one. Attorney Deaton on behalf of over 75,000 XRP holders. And what is this amicus brief regarding? These holders, a lot of which will attest that they didn't even know Ripple existed when they bought XRP. So how could they be relying on a company they'd never heard of to help increase the value of a token that they're holding? So Attorney Deaton's amicus brief is particularly strong in the fact that it does go over in more detail about how the Howey test is not applied correctly in this case. All right, so recall that the SEC has repeatedly argued that XRP is a security using the Howey test, which identified whether certain transactions qualify as an investment contract. According to the Supreme Court ruling in the Howey case, Howey test attempts to determine whether there is an investment of money in a common enterprise with a reasonable expectation of profit to be derived from the efforts of others, right? So there's 4 prongs of the Howey test. SEC fails to properly analyze the Howey test. However, the SEC has consistently failed to make the argument by effectively using the Howey test. Deaton said the SEC has struggled to pinpoint the common enterprise since the beginning of the case, right? So they really haven't done anything to prove. They've not selected any particular or specific transactions and prove that those were, in fact, illegal securities based on the Howey test, right? And that's just kind of the basis of this amicus brief. So, but these briefs are very important to this case, basically giving the court and the judge other options to look at to see that XRP isn't just an investment, right? And for most cases, it's actually used as a utility. People use it for payments. People use on-demand liquidity via the XRPL. Companies can use it for remittances cross-border, right? So there's a plethora of use case for XRP, and none of which is determined by Ripple itself. And nobody is sitting around waiting for Ripple to increase the price of XRP because, as we know, Ripple could turn around and say, hey, we're not going to use XRP token. We're going to use XYZ token instead. And there's nothing we could do about it, right? So there is no expectation for Ripple to continue using XRP. Now, if Ripple were to go away as a company, XRP and the XRP ledger would continue on because it's being used by hundreds or thousands of companies across the world, and it has an ecosystem of its own. So I do believe the judge is going to look at this. I think it might hold a fair bit of weight as to the people who own XRP, and Ripple, the company itself, has virtually nothing to do with the price of the token. So that's the hope anyway. So here is the timeline going forward. Right now, the SEC has gone ahead and filed for an extension, which they got. So they have till November 30th to file their opposition or their responses to all of these amicus briefs. I think they've agreed that November 11th is the last day that any future or any new amicus briefs could be filed. Now, once November 30th comes and goes, the judge is going to take all of this information, all of the summary judgments, all the responses, all these briefs that they're getting, and then the responses to the briefs, and take it all into consideration, and then go and deliberate herself, and which likely to take months. And a lot of the industry experts and legal experts out there are looking maybe around March of 2023 for some sort of resolution here. And it could come in many different forms. Like the judge doesn't have to just make one overall ruling on everything. Like there are different parts to this case. The judge could very well say, perhaps the first part of the case, the initial sales back in 2013, that there's still some facts that aren't really parsed out yet. That one's going to have to go to trial. But the XRP token today and future sales of XRP are not securities and they're commodities. So, there's different parts here. We don't know. Obviously, we have no idea how this is going to play out. That, to me, would be a good case scenario if they still had to work out the initial sales versus today's XRP and the future of XRP on the secondary market. That's what I'd like to see, and I think that's what most people would like to see. So hopefully we have that to look forward to. Quarter 1, 2023. I do think 2023 is going to be a big year for crypto. So that's it for the amicus briefs and all of the support that Ripple is getting, albeit, I'm going to say, kind of late. To me, it seems like a lot of these companies and industry associations waited until it looks pretty good for Ripple, and that the SEC likely to lose this case, at least lose in part, before they wanted to get involved. And I don't know, because they're trying to cover their own butts, or they just don't want to be part of a losing battle. But it would have been nice to have a lot of support from the crypto industry in general early on, instead of waiting till near the end of this case. So, but at least, they say better late than never, and we've got that support. So that's it for me. We'll see you on the next one.